forward to listening to you.
Thank you very much, Jens. Thanks to Crystal for having invited me. I thought I wouldn't have, my original thought was I wouldn't really have anything interesting to say to such a group of experts about impact assessment and the role of impact assessment in private law. But actually, on top of having learned a lot from the workshop today, I saw also that maybe this idea that I'm going to present now may have some connection with some issues that have been touched upon. I look forward to discussing it. So I'm going to speak about financial regulation and whether it can be characterized as smart according to the criteria that the European Commission has set to define regulation as smart. The outline of my talk is the following. Well, let me anticipate my understanding of this issue. I think that when this criteria is applied to financial regulation as it stands now, the initiatives that are being taken at the European level, it results in too much regulation and too little of it. And I'm going to present two examples where that shows this. The reason why, despite the commitment of the European Commission, particularly in the European institution in general, to regulation being smart, it turns out to be both excessive and insufficient, depending on circumstances, is that there are problems of political economy. Political economy has been touched upon before, particularly by Crystal herself, but also by many of the previous speakers. And I'm going to elaborate a little bit on what I mean by this problem in these two areas. The two areas in question are two topical issues developed on which the European Commission is working, the European Union in general is working now. One is like stuff from the European Commission, the last of the various action plan in financial regulation, particularly in corporate governance. So there is a plan to modernize, again, European corporate law. And the second issue is even more topical, is being advertised as a big achievement of the European Union. It is a so-called banking union. I'll say in a minute what that is. I would like to make sense also of this in a more constructive perspective. So is there any way forward? Is any way to make regulation effectively smart in the financial area? Well, I think there is. If we understand, if we use the tools of impact assessment a little bit strategically in order to cope with the political economy problem, and I would suggest two venues for doing that. One, by disciplining EU lawmaking, and the other one by separating issues of efficiency from distribution, as applied to one of these, to both this example I mentioned. So let's start, from, I mean, this is absolutely redundant now after a full workshop on what smart regulation is, but just let me try to present a very optimistic perspective on smart regulation from a law and economics point of view. So what is it that makes impact assessment very interesting from a law and economic perspective? Well, it should be a way to discipline regulation so that you start with a theory overview, you compare different theories in order to set a manual policy option to achieve certain goals. What I will not talk about here is the merits of this goal. These goals are set independently. I don't want to enter into any normative judgment here. It's just positive analysis. So assume that this way you find the right policy to achieve certain goal. And that should help, to serve the purpose of impact assessment ex ante. Ex post is even better, because you're going to check whether your policy, the policy that you've chosen as a regulator, is effectively conducive to achieving this goal. One way in which this is implemented, particularly in the ex post phase, is policy evaluation. But policy evaluation takes place also ex ante. And one of the tools that the European Commission is very proud of is the consultation of stakeholders. And in fact, it makes a lot of sense theoretically, because the people that are best positioned to assess cost and benefit of regulation are those that are directly affected by it. That is certainly the argument of the European Commission. However, let's be a little bit more cynical now. What drives regulation is not all these beautiful ideals. What drives regulation is basically the interest of the regulators. And this can be divided in these three items I'm presenting here. First of all, the politician. The politician care about one thing. They care about being reelected, because being reelected implies a lot of good things for them. From power, perquisite, whatever. We all know this. But the same applies to the bureaucrats. So also the technocrats of the process have their interest. And their interest is a complicated objective function combining monetary benefit and non-monetary benefit, what I simplified here as prestige and budget. And the fact is that both category of players, those that really determine the regulation, tends to be captured by those that are affected by it, because there are different interest groups that have a stake in the regulation being discussed. And their stake is not necessarily concerned with economic efficiency. If we analyze the tools of smart regulation in this perspective, then we may end up with a different view of the consultation problem. It's not so beautiful and so smart as it looks, because in fact, this way, this is a way in which the regulator is increasingly dependent on the interest group on information, which could be a problem so long as the stakeholders that are giving you feedback will give you necessarily a diverse feedback. And if there are no ways to choose the right feedback, let's put it this way, then the regulator is the one making the decision at the end, which implies that the regulator can be selective in processing the feedback and choose the one that suits the self-interest best. This brings me to the last item of the reasoning, that impact assessment as it stands is just too vague to commit the regulatory agency to a non-self-interest behavior in choosing between policy options, whenever this is conducive to over-regulation or excessive production of regulation. But this is not what we necessarily observe. I want to make one example in which we don't observe it. We observe less regulation than desirable in certain areas of financial regulation in Europe. Well, but the curious fact is that in these areas, the impact assessment is either waived or it's completely irrelevant. So the paradox here is that impact assessment is not useful to commit the regulator not to overproduce regulation for self-interest, but also it's not helpful to support the regulator to get regulation through when it's necessary. Let's see how this paradox applies to two areas, the two areas that I've chosen. Just starting from the modernization of company law, the action plan I referred to earlier. Well, it's the last of a long series of action plans in this field. I think it's nominally it's the second company law action plan, but I think it's the third or the fourth in the area, because there is normally an action plan on company law 1 year, and then another year there is another one on financial service. There are a lot of action plans. But it's the third, about roughly the third action plan in the area. What is the motivation to intervene in corporate governance? Again, after like 10, 15 years of debate in this, well, the financial crisis apparently shows that there was a corporate governance failure. Well, there is no single piece of evidence showing that. Actually, if there is any factual evidence data that shows something, they show the opposite. But I don't want to enter into this one discussion. There is simply no evidence that corporate governance has had anything to do with the financial crisis. Still, there is a clear stance towards regulation of corporate governance, more regulation than before, in these three areas that I listed here: transparency, engagement of shareholders, institutional investors, and cross-border mobilities of company. I want to focus on these two, because transparency is a little bit too difficult to discuss in this time frame. The point is, in general, there's one point on which most of us would agree, most of the corporate governance researchers would agree, that there is not one size that fits all company. And it's quite intuitive, because companies are different, and they may need, at different stage of development, different tools of corporate governance. So it's already a bit strange to see that the European Commission wants to intervene with one set of rules, more or less stringent. Still, there is an economic case to maximize the ability of companies to choose through regulatory competition. So there is an economic case to intervene here, like cross-border mobility of companies. The strange thing is that 10 to 15 years of action plans of the European Commission have not managed to fix this problem. On the engagement, on the other hand, there is probably no strong economic case to foster more engagement of shareholders in order to prevent financial crisis or even a less worrisome inefficiencies. But still, this is the plan for action now. Well, as I said, the cross-border mobility could help. In terms of evaluating what is already there, the European Commission has also made applied tools very similar to the setup of smart regulation, but with a very strange outcome. One item that was reviewed is, for instance, the takeover bid directive. After 5 to 6 years of implementation, and the conclusion based on an external study, very thick external study commissioned by the European institutions, is that the takeover directive works well. Again, in this document, there is no single piece of evidence. There is a survey of what stakeholders think, which can be regarded as a very more structured way to conduct a consultation. But there is no really causal evidence of the impact of this directive on the market for corporate control. So what is that the European Commission is planning to do in this field? Not much. One thing that was considered to be problematic is something that will give business to one of the newly created regulatory agencies in the framework of European supervision, European system of supervision, that is the European Securities and Market Authority. So this new regulatory agency are like looking for new business to increase their budget as any bureaucracy, and so they are getting more and more job. I don't want to get into too many details about this, but the question is, if my hypothesis is correct, there is no empirical justification and theoretical justification are at least debatable whether it's the case to increase regulation of corporate governance. How can we stop that? How can we stop the regulatory process to be self-perpetuating? And the answer, in my view, is to work on accountability. And in this respect, regulatory impact assessment and the tools of market regulation can help. But before going there, let's see how the opposite case, we could have the opposite case very quickly. An achievement of which European institutions are very proud of after the financial crisis, this kind, and this is a more related item, is the so-called banking union. So it's a system to put a supervision of banks and systemically relevant financial institutions at European level, instead of having different national supervisor taking care of it. Because, and this, the economic explanation of this is rather straightforward, there are, of course, externalities. So if there is a supervisor in a country that fails to supervise a big bank, large bank well, and this bank is interconnected with other banks in Europe, well, you all know that's a problem for everybody. So given the presence of these externalities, there is a very strong case for centralization of this stuff at European level. So what has happened is that after long and tough negotiations, the Council has managed to get unanimity that the treaty requires for taking the step that's been taken. So that supervision of a very small set of large banks will become responsibility of the European Central Bank. It's something new. For some of you may not know it. But it's been advertised as a big achievement of the European institution. Well, problem is that this achievement is such only on paper, because in fact, not only there are only a few banks that will be really affected by the new supervisory structure, but more importantly, this supervisory structure is not incentive compatible because it doesn't, it's like something that should stand on 3 legs to make economic sense, and there is only 1 leg. The other 2 are missing. And the other 2 are just not only not there for the time being, but they will not be there because they require a change of treaty and there is no potential there is no possible way, politically at this moment, how this can be achieved. I'm speaking about a resolution system and the deposit guarantee scheme that must be centralized too. You can't have supervision at the central level without this aspect, because otherwise a supervisor is not credible. If a supervisor doesn't have the access to a resolution system, it's not credible in supervisory action, because a supervisor in these circumstances will never, ever shut down a bank. At the same time, a supervisor that has the power to shut down a bank, the power to sanction bank, to tell bank what to do, but doesn't bear the cost of failing to do that, because that cost goes back to the national authorities responsible for like bank recovery resolution, then of course the incentives are not really right. So given that there is no incentive compatibility, wonder why the same system that in corporate governance is conducive to excessive regulation here is conducive to too little regulation. Well, again, the explanation is a political economy. There are interests that are prevailing, and the interests that prevail now are the interests of the member states. The interests of member states are diverse, are separated, and polarized. So there are the creditors and the debtors. They are dealing with the current situation of financial fragility, and the problem, the very contentious problem, who should pay the bill. And there is no way in the near future that member states will agree on that, which doesn't imply that the European Union and the financial system of the European Union should be doomed to fail. There are ways to get out of it. Although, for reason of time, I will not speak about this, but I want to present one of the way forward on which I believe smart regulation could be effective in disciplining European regulators. I'm referring to some work that appeared recently on the other side of the Atlantic in law and economics by a famous scholar, Jan Ayers at Yale, and was written with some co-author, that actually the impact assessment tool could be used both to commit to and to empower regulatory agency by basically writing down a rule that for any regulatory action, the regulatory agency should commit itself to an empirical way to tease out the causality of the policy. How? Well, there are two ways to do this. Either you are so lucky that the history will give you some so-called natural experiment on how comparable policy have scored relative to certain goals. This sometimes can happen. For instance, I have some views that you can use the takeover directive that I mentioned before to tease out the causality of certain effects in the European Union, because it has been applied in different ways in different countries and in different timings. The problem to establish causality is, in order to be sure that you are observing an effect, you need to always to have a counterfactual. So you need always to compare the group that's being treated, as there was a slide by Alberto Alemano showing that, with those that have not been affected by the policy. Well, sometimes it's possible. Sometimes you see that's in history and you speak about natural experiment. But what you can do in general, whenever this approach can be deployed, is to commit to apply the policy under debate only for a set of people affected, but not for everybody, in order to make an experiment called policy experiment about the effects that this policy is determining. There are a number of advantages in this. First of all, the policy evaluation is not something vague. It's not something that you are delegating to a group of stakeholders, and then the regulator chooses the feedback that likes best. No, it's something more objective, because there is an empirical result, a set of empirical results that are telling objectively what are the effects of a certain policy. But also, there is another important effect. Not only this way you can discipline the bureaucracy that is supportive of a certain regulation, because then at the same time this rule of law would commit the regulator to the experimental result, but also the politicians would be more accountable for the intended goal on which they are elected, and less exposed to the pressure of the interest group. in this way, it is also possible to imagine that a policy that is opposed, that is controversial, could be agreed upon by the two opposite parties once it is decided ex ante with a credible commitment that whether the policy is continued or discontinued after the testing period will be decided by the results of the policy experiment. And in a similar way, but I don't, for the interest of time, I'll skip that, you could use political economy to have to get out of the problems of endowments with member states in deciding the way forward for banking regulation. But thank you very much for your attention.